A testator is a person who leaves a will in force at their death. And a will is a legal instrument which states how the testator's property is to be distributed at death. A valid will avoids many of the problems that may arise from dying without a will, and it allows for a person to leave the property to persons that he or she so desires. In addition to naming the recipients of the testator's property, the will also designates the individual or individuals who will manage the property and care for minor children. In larger estates, the will often contains provisions that minimize its taxes. Hi, I'm Kizzy, Certified Probate Real Estate Advisor, which means that my team and I specialize in helping executors, administrators, and trustees with homes in the probate or a trust administration. In this week's video, I am explaining how to execute a will. In order for a will to accomplish any or all of these results, it must have been properly signed. Texas recognizes handwritten wills, aka holographic wills, and typewritten wills, aka formal wills. Under the Texas Probate Code, a valid handwritten will must be wholly in the handwriting of the testator and signed by the testator. It does not need to be witnessed, and it can be written on anything, including stationery. Typewritten words may not be incorporated into a handwritten will. The wording must reflect a present intent to dispose of property at death. The words, "This is my last will and testament," generally are sufficient to show testamentary intent. Further, if the handwritten will does not contain the proper language allowing the executor to serve without court supervision and waiving bond, the executor may be required to obtain court approval of many actions and to post an executor's bond. This causes unnecessary delays and expenses in administering the estate. For these reasons, the best approach is to have an attorney prepare a typewritten or formal will for you. A typewritten will sometimes is referred to as a formal will. It is a well-drafted typewritten will, and it is more apt to carry out the decedent's intent. Although a typewritten will may be prepared by a lay person, an experienced attorney should draft the will. For a typewritten will to be valid, it must meet these requirements. Number one, it must be signed by the testator or another person at his or her direction and in his or her presence. Number two, it must be attested by 2 credible witnesses above the age of 14. And number 3, it must be signed by the witnesses in the presence of the testator. A beneficiary under a typewritten will should not serve as a witness to the execution of the will, because this may preclude the beneficiary from receiving any property under the will. Whether you have a handwritten or a typewritten will, its validity must be proved in court. This procedure is known as probate, and it generally must take place within 4 years after death. To probate a will, it must be established in court that the will meets the requirements of execution and that the will was not canceled or revoked. Additionally, unless the will is self-proved, proof of a handwritten will requires the testimony of 2 witnesses to the testator's handwriting, and proof of a typewritten will requires the testimony of one of the attesting witnesses. A self-proved will is one that has attached a specific form of affidavit containing certain requirements, which is executed before a notary public at the time the will is signed or any time thereafter, but before the testator dies. A standard notary acknowledgement alone is insufficient to make the will self-proved. A self-proved will is admitted to the probate on the basis of the self-proven affidavit, and there is no need to call witnesses. A will that is not proved in court is denied probate. In this event, the decedent's property passes to his or her heirs as if he or she died without a will. Again, this further emphasizes how important it is to execute a will which meets all legal requirements so that property will pass as the testator wishes. After proving the validity of a will, the next step in the probate process is the administration of the estate, which we will talk about in next week's video. If you are planning to sell a home in probate, I do have a free Texas probate guide that I would love to send you. You may request it via email at kizzy.grant@exprealty.com. And just simply state, hey, I am requesting your free Texas probate guide. And I will send that right over to you. Again, as always, thank you for watching. If you found this video valuable and helpful, please like and subscribe to my channel, and also click that notification bell so that you will be notified when new videos are released. I will see you in the next video.